Next matter come before the court this morning. Duane Meade, Administrator versus Meade Regional Medical Center. Each party will have 15 minutes in which to present the case. Here the appellant and the issue retain some of that time for rebuttal. Let me know when you come up to the front podium here. I'm keeping track of the clock and will keep you apprised of the passage of time. We are being visually and audibly recorded to be posted online, so please try to remain behind this front podium as much as possible. We have read your briefs and we're ready to proceed when you are.
May it please the court, my name is Leah Dugan, and I am here on behalf of appellants Mercy Health Regional Medical Center, LLC, Mercy Health, and Mercy Health Lorain, LLC. I would like to reserve 3 minutes for rebuttal. Thank you. We are here today because of the trial court's erroneously inconsistent holdings with regard to peer review privilege in this case. At first, the Mercy defendants prevailed in July of 2017 when the trial court held that a number of documents submitted at an in-camera inspection were subject to the peer review privilege as outlined in ORC 2305.252. But when confronted with interrogatories carefully crafted by plaintiff to elicit the information contained in the privileged documents, the trial court in March of 2018 reversed its position and went against the law contained in both the peer review statute and a number of Ohio rulings, including Cusino versus Mercy St. Vincent Medical Center, a 2018 case before the 6th District Court of Appeals. The trial court erroneously ordered the Mercy defendants to provide answers to interrogatories that were obviously seeking the privileged information contained within the very same documents that the trial court had designated as privileged in July of 2017. Appellants respectfully request that this court reverse the trial court's March 28, 2018 order granting plaintiffs' motion to compel answers to interrogatories numbers 1 through 12. When appellants first received plaintiffs' request for production in 2017, the Mercy defendants appropriately responded by seeking a protective order and submitting the privileged documents to the trial court for review. In the July 31st, 2017 order, the trial court delineated a list of documents that were protected by the peer review privilege. According to Bansal versus Mount Carmel Health System, it is the party who asserts the privilege who has the burden of establishing that the privilege exists. And that burden can be established in 2 ways. Either submit affidavits and testimony substantiating the privilege, or by submitting the documents in question to the trial court for an in-camera review. In this case, the Mercy defendants met their burden in establishing the privilege by submitting the documents to the trial court. The list of documents that was provided by the trial court in the July 31st order was a list of documents that the plaintiffs knew they would not be permitted access to in discovery. So after appellants filed their motion for summary judgment in December of 2017 on the negligent credentialing issue, plaintiffs asked for more time to conduct discovery on the negligent credentialing issue, and in January of 2018, they created interrogatories that, while they do not specifically ask for X document from the privileged list or Y document from the privileged list, they were designed to obtain narrative explanations of the privileged information contained in the documents that the trial court said were privileged. For example, interrogatory number 1 stated, identify and explain any gap or change in Alexander Zali, MD's clinical privileges at defendant's facilities. Interrogatory 2 is worded the same way, but instead of asking for the gap or changes in clinical privileges, they asked for the gap or changes in his staff privileges. These 2 interrogatories are obviously attempting to obtain the information contained in a number of different documents from various years that the trial court stated privilege. There was correspondence regarding Dr. Zali's appointment of privileges, his reappointment of privileges. There was information regarding his application for privileges. Those two interrogatories are asking for the information contained in these
So did
documents.
you file an affidavit or produce the documents for in-camera inspection at that time?
No, they were only for the July order. That is when the documents were submitted for the in-camera
And
inspection.
they were the same documents.
They were the same documents. Similarly, interrogatory number 12 asks to identify and explain changes in Zali's application for surgical privileges. Again, that is going towards those documents that were submitted for the in-camera inspection in July of 2017, which cover his surgical privileges applications, his reappointment of privileges applications. They are asking for the information contained in those documents. These are the documents the court already deemed were privileged, and in accordance with the Mercy defendant's motion for protective order and request for in-camera inspection that occurred back in July of 2017. The plaintiff should not be permitted access to the privileged information. Cook versus...
Did you file I'm trying to set this
Sure.
forth in my mind. They send you these interrogatories. Did you file some sort of an objection with the court, or did you just disregard them?
So we objected to the interrogatories and provided those answers to plaintiff. They replied with the motion to compel, and we opposed,
Okay.
and then the
I couldn't remember what
yeah, the
the
motion to
procedure
compel.
was. Thank you.
Sure. So Cook versus Toledo Hospital, in that case, the 6th District explained that the legislative intent of the peer review statute is to provide a complete shield to discovery of any information used in the course of a peer review committee's proceedings. ORC 2305.252 also protects documents that are maintained in the peer review committee's records that were generated by an original source and then produced and used in the peer review committee. These documents can only be obtained from the original source. 9th District held in Abels versus Ruff, a 2005 case, that the trial court had erred by granting the appellant hospital system in that case to produce credentialing documents that were generated by an original source, noting that they must be obtained from the original source itself, not from the appellant hospital system. Appellees in their brief state that the information and documents requested in the January 2018 interrogatories are all available from original outside sources and that are not the peer review committee, but that is not true in this case. They do give the concrete example of their request for production, which did ask for billing records, which would be, the billing department would be an outside source, but we are not arguing about the request for production in this case. It's solely the interrogatories 1 through 12. Plaintiffs state in their brief that the information and documents, or the information requested in these interrogatories could be obtained by anybody who scheduled Dr. Zali or who maintained the hospital's website, that they would have information regarding changes to his privileges or changes in what sort of procedures he was permitted to do. But it remains that those interrogatories were not directed to some random personnel at Mercy who maintain the website or who take care of the scheduling. It was directed to Mercy. The risk manager is the one who answers these requests. She is involved with the peer review committee. She is involved with credentialing. She is not an outside original source. As the risk manager, so she was involved with the peer committee and she's not an outside original source. But plaintiff, they're not completely wrong. The answers to the questions about Zali's privileges and credentialing can be obtained from an outside original source, but it is not the Mercy defendants. An appropriate original source in this case would be Dr. Zali himself. The 6th District noted in Cusino versus Mercy St. Vincent that a physician is a fine outside original source for information or records regarding his education, medical training, licensing, and any information regarding past lawsuits or disciplinary actions. In this case, appellee had deposed Dr. Zali and had opportunity to obtain the answers to these questions regarding his credentialing directly from an original source.
Counsel, had they done that, where would they have had the opportunity to try to determine whether his answers were credible? Might be a moot issue if they
Well,
didn't ask him those
right,
things,
right.
but certainly wouldn't that have been the natural follow-through?
Well, whether he is credible in answering those questions, that would be a question of whether he appeared credible or not, right? And that would be a question of
Oh,
fact.
goodness, I hope. Okay, never mind, go ahead.
Oh.
Go on, I'm sorry.
Okay. So, in this case, they did depose Dr. Zali, they did not ask the questions. And they waited until appellants filed their motion for summary judgment on the negligent credentialing claim to say, oh wait, we didn't get all these answers, and then tried to get the answers from Mercy, which is not an outside appropriate source in this case. The trial court cannot, on one hand, delineate the peer review credentialing file as privileged under ORC 2305.252, and then on the other, order the Mercy defendants to provide plaintiff with answers to interrogatories that are basically requesting Mercy to explain the contents of the privileged documents. The trial court was incorrect in their conclusion that allowing plaintiffs the discovery of privileged credentialing information is the only way to prove a negligent credentialing claim. No document existing in that file must be produced because no documents can be obtained from a peer review committee's records period. The same goes for describing the documents as an answer to an interrogatory. In Smith versus Cleveland Clinic, the 8th District stated the purpose of the peer review statute is to protect the integrity and confidentiality of the peer review process such that healthcare entities are free to meaningfully review, critique, and improve the quality of healthcare services they provide. Creating the peer review privilege was a policy decision made by the legislature to encourage healthcare entities to provide a safe and confidential environment for the critique of their own physicians in order to improve the quality of the healthcare delivered by the healthcare entities. The legislature's intent is clear. The Mercy defendant should not be compelled to provide the plaintiff with privileged information, whether it is giving them documents or whether it is describing the contents of the documents.
So these interrogatories could have been sent to Dr. Zali himself, were
They
they?
could have. They could have.
Were they?
Not that I'm aware of. In the March 28, 2018 order, the trial court cited Wilson versus Barnesville Hospital for its basis of the order compelling the Mercy defendants to provide answers. The court in Wilson held that ORC 2305.251, which is different from 252, 251, does not provide blanket immunity for negligence in the granting or continuing of staff privileges to an incompetent physician. The Mercy defendants are not asking for blanket immunity on a negligent credentialing claim. The Mercy defendants are asking for consistency from the trial court with regard to information that was already deemed privileged by the trial court and for consistency with Ohio law.
You have just over 3 minutes total.
Okay, I'm just wrap this one up. Good. All right. The 6th District Court of Appeals considered the same issue in April of 2018 this year. The 6th District stated, it is more important to protect the absolute confidentiality of a credentialing committee's proceedings and records to ensure that its participants are free to engage in a meaningful and honest review of its providers, which should lead to an overall improvement of healthcare services as a whole. Given that public policy is the province of the legislature and not the court, we are bound to enforce the law as written. Appellants respectfully request that this court follow the 6th District's lead in Casino by maintaining the peer review privilege regarding the information which the trial court already held was privileged in July 2017 and reverse the trial court's March 28, 2018 order granting plaintiffs' motion to compel answers to interrogatories 1 through 12. Thank you.
Good morning. May it please the court, my name is Paul Flowers. I'm representing the plaintiff appellee, Duane Meade, who is the administrator of the estate of Meade. I'm joined by a Lewis crew from my office, Chris and Calder Molino in the back of the courtroom, our trial counsel. I thought I'd start with Judge Schaefer's question, dealing with the documents. I'm not sure this really matters anymore from what I heard subsequently, but our answer is no, we're not dealing with the same documents. This is the second request for production documents that seeks records that are financial. It's the revenue statements, billing records, so forth for Dr. Zali, the income the hospital has just generated from his services. It's inconceivable that that could possibly be peer review, yet peer review objections were raised to that. It was part of the brief, and I think now they're saying they're no longer pursuing the objections to the document requests, that really leaves us with very little, because the peer review statute, I mean, the exact words are, it protects proceedings and records. We're dealing now with just interrogatories, seeking information from the hospital that the hospital possesses, not documents and records. And I understand you can't use an interrogatory and say, you know, hey, what did that witness statement say that you had in your peer review committee? You can't do that. But that's not what's happening here. It was surprising to me how little we heard about Judge Maraldi's actual reasoning. What Judge Maraldi said here is that, look, we've been through this before, we get that. Here, all they're seeking through the interrogatories is the outcomes. Was this man suspended? Was an investigation done? Did he file an appeal? Those are historical, fact-based questions, and no, it's not appropriate for Dr. Zolli to answer that deposition. This is the negligent credentialing claim against the hospital. The hospital possesses that information. It's the hospital that is credentialing Dr. Zolli. It's the hospital's decision. It's not up to him. So, yes, this is all very standard, very common questioning that you ask in a negligent credentialing claim. And it's just, the point is just to establish, you know, what is his historical background, how has his credentialing gone over the years, is this a situation where from the billing records we know the hospital's making a lot of money from him, but they turned a blind eye. That all needs to be investigated, and this is absolutely the proper way to do so.
Counsel, let me ask you, as you posed those questions to us, they were clearly, could be answered yes, no, no, yes, but didn't the proposed interrogatories go beyond that and require explanation that could arguably be privileged?
Yeah, it's, first of all, I think a lot of it is just yes, no, you know, was he suspended, so forth. The explanation would just be details as in what's the public knowledge, what's the background information that's made on public knowledge, but what's the background of this? We understand from the judge's first order and from the statute, you can't ask what happened at a peer review committee. You can't get into that. But what happened with him, his credentialing, that is something that patients are entitled to know without getting into. So I think all the interrogatories can be answered without getting into anything that happened at a peer review committee. And just, I think we need to back up a bit, maybe a lot, because Judge Teodosio raised a good point, which is there an affidavit here? And the answer is no. We don't know what it is that is about this information that is protected by the peer review committee. We don't know that a peer review committee even met to address this. And this is important. I mean, we all agree on this in the briefs, but they have a rather heavy burden of proof. So the Bailey versus Manicare case, which is an 8th district case that's cited quite a bit, they have the burden to establish first, a peer review committee was in existence. Second, that the facility actually investigated the incidents at issue. Here would be credentialing. And then the court specifically states, the party must also show that each of the documents over which it asserts privilege is a record within the scope of the committee and provide evidence as to the specific documents requested over which it asserts the privilege. We have none of that here. Now, we're not talking about the document requests anymore, but as far as the interrogatories, they don't even explain, you know, what it is about this information that would be part of a confidential peer review process that actually happened. This Cousineau case that they're talking about that came out earlier this year from the 6th district, I have no problem with it. I mean, in that case, the court very carefully explains how the hospital submitted 2 affidavits. And it quotes the affidavits that are very thorough in explaining how there was a peer review process. The records that are being sought are part of the peer review file. Either they're confidential because the committee created them, or they were obtained from outside sources. And the court says, very simply, you can't get into their file. Cousineau has no application here because we're no longer talking about document requests. No one's trying to get into the peer review committee records. What Cousineau does say is in paragraph 28, the defendant, Mercy St. Vincent, quote, must separately establish that each of those documents are records within the scope of the peer review committee. And they give the example of an incident report. You know, it's just because the peer review committee looked at the incident report doesn't mean that it's privileged. It's not privileged anymore. And since it was created by the hospital, it's discoverable. It's not an outside source.
Counsel, on the argument you're making now regarding the burden of proof, the trial court didn't conclude that Mercy didn't meet its burden, correct?
Yeah,
The trial court actually addressed privilege and whether the information was or wasn't under the peer privilege statute. So if they didn't meet their burden, didn't the trial court err in that regard?
well, I would say no. It is part of being the appellee here. It's a nice thing because I don't need to win on the same grounds as the trial judge. I can win on any grounds as long as it justifies what he did. And here he took one path, which is what you just described. It makes sense to me. I think he could also said, there's no affidavit here. And personally, I've never seen a peer review claim that is not supported by an affidavit. I mean, this is the first time for me that somebody didn't just put out something from a hospital administrator saying, hey, all this information was part of this committee that met, in March of 2017, blah, blah, blah. We don't have that. So he could have gone that route too, which would be an alternative ground for affirming the trial court. And I think if I could pick on Judge Moraldi a little bit, he's saying, we're not going to include the results and outcomes within the peer review statute because there's no way to establish a negligent credentialing claim otherwise. That's sound logic, but I think even more fundamentally, you could say, it's just not covered in the statute in the first place. I mean, the opening words are proceedings and records within the scope of the peer review committee. It doesn't say anything about the results and outcomes. That would make no sense. How are you ever going to know whether a physician is properly credentialed in the hospital if you're not allowed to discuss it? And that's the kind of thing we're talking about here. An example might be if a lawyer counsels a client in a criminal case to enter a guilty plea, absolutely that discussion is privileged. But the fact that the client then makes the plea is not. He's doing that out in the open. Here, if they suspended Dr. Zolli, if they withdrew his credentialing, if they did any of those things that are requested in those interrogatories, that's something that patients are entitled to know. It's not going into the process of the peer review committee. It's just the results that happen. And again, not to get ahead of ourselves, we're not even sure that happened here because there's no affidavit. There's really just no way to tell what's going on and why this is privileged. So just circling back to the beginning of your question, Judge Callahan, I think there's lots of different ways to reach the same result here, which is affirming Judge Moraldi, who, particularly now that we're not even worried about documents anymore, we're just looking at interrogatories, but his ruling is spot on and certainly well within his discretion. So we ask you to affirm the trial court. Oh, that was good. Thank you.
Thank you. Thank you. No, just over 2 minutes.
2 minutes, thank you. All right. Just a couple of things I want to address here. All right. The first one is the burden of proof was met. No affidavits were necessary. No deposition testimony was necessary because there was no dispute over the existence of the peer review committee and whether any of these documents were reviewed in the course of the peer review committee and used because the trial court in the in-camera inspection said, yes, there was a peer review committee, yes, these documents were used within it, yes, they are privileged. Whether or not there's an affidavit or deposition, we're beyond that because the burden was already met in 2017 with the trial court. I also just wanted to note that the standard of review here is de novo. Typically discovery orders are interlocutory, but in this case, ORC 2005.252 states that any judgment compelling the production of documents or information that was delineated as protected by peer review privilege is final and appealable order. Medical Mutual of Ohio versus Schlager, the Supreme Court of Ohio stated that, yes, this is a de novo review is the standard. And then the last thing I want to address was just these interrogatories were not yes or no questions. They were a yes or no question where if the answer is yes, then it wanted much more detailed information, basically describing the documents that are delineated as privileged. So, for example, interrogatory number state whether Dr. Zolli has ever been involved in or subject to any summary suspensions, automatic suspension, termination, or revocation under Article 9 of the appellant's bylaws, and identify the date and the reason for any suspension, termination, or revocation. It's not just asking if he was suspended, it's asking when and why he was suspended, which is information that would be covered under the privileged documents. To conclude, appellants just request that this court reverse the trial court's March 28, 2018 order granting plaintiffs motion to compel interrogatories 1 through 12.
Counsel, is Mr. Flowers correct? I took it this way also. There's no dispute about the production of documents.
The production of documents, we had objected on those based on confidentiality, so that would be an interlocutory, so yeah,
Thank you.
That's correct.
Thank you both for your presentations today. The court will take the matter under advisement and issue a written decision, which will be mailed to both sides as well as posted to our website and that is